what Ms. Perry dealt with. I haven't gone back and read the record. I have my memory, though, and I have the credibility of the witness. She was troubled at work. She lost her hair. People don't lose their hair over nothing. This was more than just a loss of promotion. This was a hostile work environment claim. I don't know why it wasn't pled that way, but I might equate it to a battered women's syndrome. Sometimes when people are in a situation of being battered and bullied, they don't know that that's what's going on. They blame it on other things. I think what happened here was Ms. Perry was believing that what she was feeling was she was at work not getting promoted and blaming all of her frustration on that, when in fact she was dealing with a hostile work environment. And the communication that she gave to her lawyer was based on, I'm not getting promoted. When in fact what she should have been conveying was, I'm in a really bad hostile work environment situation. And that's a very tough thing to convey. And it's a tough thing to work through. And I think that when she was in this courtroom and it all came out, maybe then she realized, when she actually uttered the words in open public and saw that photograph, and I saw her face, maybe then she realized how bad it was. And maybe that's why it wasn't pled as strongly as her counsel might have otherwise pled it. But believe me, it was there. And that is why I gave the award that I did. And why I feel so strongly about it, I don't have to reiterate what I said. Sometimes, as we know in the law, res ipsa loquitur, the thing speaks for itself. I think Smith versus Corey speaks for itself as well. This part about the opposing party, the party who wants this fee not to be what's been presented to the court, is the one who must request an evidentiary hearing and then challenge what they don't like. I have not heard the department go line by line through the bill and tell me what they don't like. That is how I read Smith versus Corey. It is not this court's obligation to go through the bill and look at each charge and find what's unreasonable. I've gone through it. As an attorney, I see nothing wrong with the bill. Therefore, this court is awarding $49,800 as requested, because nothing's been specifically challenged except the department simply doesn't like it. That is the ruling of this court, counsel. You will prepare the order free of charge.
Yes, I will, Your Honor. Thank you.